matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernardo Wusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m., Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernardo Wusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.
Hello. You're welcome to hanging out with BWF Solicitors. I hope you are all keeping well. We've come your way again today with this new topic that we have that my learned solicitor, Lawyer Eunice, will be taking us through this topic. The topic is how important it is to meet the English language requirements when applying for leave to remain. You can watch us live on Facebook, YouTube. I think we have a radio app as well, BW Radio, that you can listen live. We would love to hear from you on all our social media handles, especially Facebook, YouTube. If you prefer to contact us live on this program, you can do so on 0744 8619 711. The number again is 0744 8619 711. You can also WhatsApp your questions to me on the same line. Let me quickly welcome Lawyer Eunice Achampong, who is a partner and also a solicitor at BWF Solicitors, the number one solicitor firm in the UK, specializing in immigration and nationality, Ghana law and practice, family law, dispute resolution. Lawyer Eunice, you are welcome to today's program.
Thank you so much, Vicky. How are you?
I'm good, and you?
I'm doing well. It's been a while.
You look different, and I think about 5 years younger. If I
should say. Thank you.
Yeah. Meaning you're taking good care of yourself, irrespective of the stress you guys go through with the pile of casework. I can
Yes.
just imagine.
It's good to take time off and just recuperate and just come back to it
Mm,
all over again. So I think rest is good.
great, great, great. Like, do you have any updates for us before we go into the today's topic?
Yes. And so I think most people would know that I'm very big on our skilled worker scheme and very much so when it comes to our health and care visa applications as well. And so just 2 weeks ago, the government announced that they were now going to introduce specifically care workers to the
Yeah.
eligible occupation list. So not only was it to do with health professionals, because they had a general should I say, occupation code or job for health professionals, which included care workers and other health professionals that were not specifically mentioned. And so now they've specifically mentioned care workers and care assistants and the rest of it. So it makes it much easier for the care industry, the nursing homes, to be able to recruit specifically for those roles. Obviously, people that they would employ if they were employing outside of the UK will have to meet the specific required um, skill level English, and obviously if they are applying, they should have the appropriate salary level as well. So all of those things come with it, but it's great that they've now seen the need to be specific and have care employers employ specifically under that route.
Right.
Um, Also, I think that many people have been wanting to hear so much about the case of Akinsenya. So, when it comes specifically to those that are Zambrano carers, so those that, for one reason or the other, currently are on the 2.5 year route and are now thinking, well, the EU Appendix EU offers most people the right to apply for indefinite leave to remain if they are Zambrano carers. And a lot of people did not have the chance to do so under our previous EU regulation 2016. And so, of course, it was a big thing when this case of Akasenia came about, and we had Miss Akasenia say, well, I only switched to the 2.5 year route because I wanted access to benefits. And of course, uh, court, the High Court judge, Judge Moss, agreed with her and said, well, she should have the right to switch back to the Zambrano route because of the fact that she previously was on it and then switched to the 2.5 year route. The Home Office did not like the fact that she could um, easily switch back to that route just because she wanted to gain indefinite leave to remain. And so they appealed, and they appealed to the Court of Appeal. And so the Court of Appeal made their decision on the 25th of January this year to say that, yes, of course, we now see where the Home Office is coming from, and we also have taken in view what Ms. Akinsenya is also saying in regards to her leave to remain application. And in regards to what the Home Office said, they looked at the fact that when it comes to Zambrano carers and their derivative rights, Zambrano carers under our previous EU, or should I say previous EA regulations 2016, would have had the right to apply for derivative rights because they were the main primary carers, and therefore could apply for such right to remain with the British child because they wouldn't have any other primary carers to look after their child. And of course, when it comes to the home country, which is the UK, providing a means by which um, a primary carer can also remain in the UK, then of course, the option of, let's say, a single parent applying under the Zambrano route would have been a no-go area, because of course they look at the fact that there are no exempt persons such as a British parents who can look after the child, or a settled parents who can look after the child if the other primary carer were to leave the UK. So in that instance, the Zambrano route was specifically for those people who were not offered that right under our immigration rules, like we have under our leave to remain in Appendix FM. So the Home Office made their point, and the Court of Appeal agreed with that. But when it comes to the fact that, of course, you will have primary carers who will not be afforded a right under our usual immigration rules, then there should be that instance where they should be able to be given that right to make that application under the Zambrano route, because the immigration rules or the country's legal framework does not allow for them to be granted leave to remain, or be granted indefinite leave to remain. And so, of course, if there was no instance for such a primary carer to be given a 2.5 year leave to remain, and they had to get that Zambrano right to remain to be able to get the indefinite leave to remain, then of course they should be given that right to make the application under our Appendix EU for derivative rights, and then attain indefinite leave to remain after a period of 5 years. And so it makes um shall I say, a win-win for both both teams. So the Home Office made their point, and so did Miss Akinsenya in her case. The Court of Appeal, I would say, was very diplomatic in their decision making, and so it does make sense that those that don't have that particular right to make an application under our immigration rules will then have the right to make sure that they can apply under the Appendix EU for derivative rights as a Zambrano carer, and then go ahead to apply for indefinite leave to remain. So I guess those primary carers who are eligible can now make their applications for Appendix EU derivative rights to remain in the UK. And then, of course, if you are somebody who is a joint primary carer, so both parents without leave to remain, yes, you can go ahead and then make the application for um, indefinite leave to remain after a period of 5 years as a Zambrano carer. Yeah.
Wow, great. So such a good news. Ladies and gentlemen, if you've just joined us, this is Hanging Out with BWF Solicitors. I'm your host, Vicky Newton, and with me today is partner and also solicitor, BWF Solicitors, Mrs. Eunice Achampong. Today we're going to delve into how important it is to meet the English language requirement when applying for leave to remain. We would love to hear from you. Send in your questions on all our social media handles, especially Facebook and YouTube. You can also call us live in the studio on 0744 or also WhatsApp us on the same number 0744 711. Now, your lawyer Eunice, who needs to meet the English language requirement, and how can the requirement be satisfied?
So, in regards to our immigration rules, when we generally look at those who are applying for leave to remain, so I'm sure that there are other routes that have the requirement of meeting that English language. So, a few could be those applying as students, those applying as skilled workers, those even applying as Appendix FM armed forces family members. So we're dealing specifically today with those applying for leave to remain, either as a parent or as a partner. And when you look specifically at Appendix FM of our immigration rules, there are different requirements in meeting. Whether you are a parent, there are requirements you have to meet. If you're a partner, there are requirements that you have to meet to be able to be granted 2.5 years leave to remain.
Okay.
Depending on the requirements you are able to meet, you will either be put on the 10-year route to settlement or the 5-year route to settlement. So if you are able to meet all of the eligibility requirements and the suitability requirements, you are going to likely be put on the 5-year route to settlement, which means that after a period of 5 years, you can apply for indefinite leave to remain. Whereas those that are not able to meet all of the requirements may be put on the 10-year route to settlement, which means that after a period of 10 years, you can then apply for indefinite leave to remain. If, of course, you are not able to meet all of the requirements and you are able to meet exception one of the immigration rules, then of course, there is no need to meet that English language requirement. So, a requirement could be that you have to meet the English language requirement before we can grant you leave another 5-year route. But there are exceptions, and that's why I mentioned if Section 1A applies, then you do not have to meet that English language requirement. When it comes to those, of course, who are going to be able to meet all of the requirements, which include the relationship requirement, the financial requirement or the maintenance requirement, the accommodation, and also the immigration status requirement. You also have the English language requirement, which the applicant has to meet. And usually, the person who they are referring to is somebody who is between the ages of 18 to 64. So if you're between the ages of 18 to 64, then you are the person who has to meet that English language requirement. Unless you can prove that you are 65 and over, or you have some form of disability, whether it's a mental disability or some form of physical disability, which prevents you from meeting that English language requirement. Or there are some exceptional circumstances in your case which prevent you from meeting that English language requirement. But generally, any applicant who is between the ages of 18 to 64 has to meet that English language requirement when applying for leave to remain. When, of course, you are looking to see how a person can meet that requirement, then you're looking to see if, for instance, the person is from a majority English speaking country, and it's not every country where English is spoken, which is a majority English speaking country. The immigration rules are very specific, and they've listed just about 18 countries under Gen 1.6, which they believe to be the countries that are majority speaking, English speaking countries. And so, unfortunately, most African countries do not come under that list. So you have countries like Canada, Australia, New Zealand, America. You have some Caribbean countries like Jamaica in there as well. But most African countries, unfortunately, do not come under this list. So, of course, if you are from an African country where English is spoken and you think that it is a majority English speaking country, then please do not assume that, because there is a list that they look at. If you are not from a majority English speaking country, what they tend to look at is whether you have passed an English test, which is for speaking and listening. So prior to the rules changing in 2012, most people would have done English speaking test, which will assess their speaking, listening, reading, and writing. But specifically under our Appendix FM, they are assessing your speaking and listening skills. So they want to see if you've been able to pass a test which has speaking and listening, and it has to meet a minimum common European framework level A1. So that is basic English. So when they say level A1 or level A2, it means that you are meeting the most basic form of speaking or listening in English. And of course, if you are from a country which is outside of the UK and you have a qualification such as an undergraduate degree or a master's degree or a PhD degree, you can use that as a means to meet the English language requirement. If, like I've said, it's from outside of the UK, you have to have ECTS, which is the body that assesses whether most qualifications meet that required common European framework level that is needed. So most of the time, those qualifications will be sent off online for assessment. I think there's a fee that has to be paid to actors for them to do that assessment as well. And so once you've been able to provide the confirmation from actors that it meets that required framework, then of course you can use that as evidence that you do satisfy that English language requirement. So either you're from a majority English speaking country, or that you've passed an English language test, or that you have a qualification which is either a master's or a bachelor's degree or a PhD, which meets that required English language framework. So either of those will help satisfy the requirement that you can go ahead and then meet the other eligibility requirements needed on the route that you are on. Yeah. Can you hear me? For some reason, I can't hear you.
Sorry
Okay.
about that. Yeah, so like as I was saying, are these English language requirements a way to cut down on the cost incurred on translators in this country?
Well, well, they see that those that are not able to speak English become a burden on the state because, of course, like you're saying, you will need interpreters. And not only would you need interpreters, that means that everywhere they go, somebody has to now come to a very basic level of speaking in English and spend time interpreting what they really want from them before they
Yeah,
can actually access anything from that person.
yeah,
So, can you imagine um let's say somebody who has just come to the UK, they have no knowledge of English whatsoever. They need to go to the GP. The GP is asking them what is wrong with you. They have
mm,
no clue what the GP is saying. They
yeah,
cannot communicate back to say, this is what is wrong with me. And how can the GP then prescribe something that is necessary for you if he can't also understand what you want to tell him?
mm,
And so most of the time you find that where there is very should I say basic level of English and people are finding it difficult, um, there are those that will try and make the effort and learn the English language and they will go to those basic English classes just to pick up some English. And then there are those that will tell their family members, I'm going to the GP, can you come with me? And that is such a hassle because are you always going to go with that family member to the GP? Are you going to go with that family member for shopping? Are you always going to go everywhere with that family member? and so it makes life a bit difficult for other people as well. And so they want people to make the effort to at least speak the basic form of English. And
Mm.
of course, when it comes to those that even need to apply for indefinite leave to remain, there is a rather higher level of English language that they require, because
Oh,
if you're going to apply for indefinite leave to remain, which they think means that you can live in this country permanently, then you
yeah,
should be able to
exactly.
communicate
Exactly.
independently without anybody's supporting you. And so,
Right, Eunice, I've got a caller on the line. Hello, caller. What's your name and where are you calling from?
Yeah, I'm a participant of. I just want to make sure if what lawyer is saying about B1 is to for the Kenya application.
Right,
Because
Eunice,
I'm
did you
not
hear
sure
a
if I'm
question?
sorry.
I wasn't clear on it. So,
Okay.
what was the
Can you
question?
turn down
I
the
just
volume
want to
of
make
your
sure lawyer
TV
is saying
or
that
what you watch?
the
I think we
B1 is
can get the
the
feedback.
home office.
Hello?
I said I just wanted to make sure if what lawyer is saying, what the home office has brought for that Kenya application. Thank you.
Okay, so
What
she's
Eunice is saying about that Kinsenya case? Hello?
I think from what I heard, she was trying to find out if what I was saying is also similar to what the Home Office have said.
Right.
I
Right.
think that's
Okay.
what she said. So,
Okay.
of course, when it comes to the judgment, the Home Office is now yet to implement what the Court of Appeal have also stated. So
Okay.
they are going. Usually, what happens is that when a case comes out and they need to make changes, um, the immigration rules are known as secondary legislation. So it is not made in Parliament. It is made by the government department that deals with UK visas and immigration. So that's known as secondary legislation. So at some point in time, they will make the necessary changes to the immigration rules. But most of the time, what usually happens is that they will um, make a policy change. So in their guidance, they have their own policies. They will implement it in their guidance so that most people will know that this is what they're about. But as I was saying, the court judgment was to say that, of course, we know that when it comes to primary carers, primary carers who can show that they have looked after a Zambrano child, so a child who is British and would not want to leave the UK,
Yeah.
has obviously got that right to remain here with their primary carer. And when you look at our previous EEA regulation 2016, that primary carer will be somebody who was not also an exempt person. So somebody, for instance, who was not British or is not settled in the UK, for instance. So, of course, if you are a primary carer of a child, and obviously you are making the argument that because you are a primary carer, you wouldn't have that right to live in this country unless your child, who is a British child, was allowed to live here in the UK. And of course, when it comes to British citizens, they're very permanent thing that most should I say caseworkers will look at is the fact that they are looking at the best interest of that child, and that will include the rights that they have as British citizens to things like free education and the fact that they have the free healthcare, and they've also been rooted here in the UK and the rest of it. So they look at the child's best interest as being paramount. And of course, when it comes to primary carers and the fact that they have that right to make the application for derivative rights, they assess all of these things. When the Home Office obviously have made their assessment to say that well, we believe that this parent who is also a sole carer of this child can also derive, let's say, leave to remain in the UK. So we know that under our Appendix FM, most parents who can show that they have sole responsibility or they have direct access, or the fact that they normally live with the child, will be able to apply for leave to remain. And so, where the immigration rules do not afford somebody the right to make such an application, then of course they have to have the right to make the application under Zambrano. And so that is where obviously most primary carers will be able to make the application if, for
Mm,
instance, they
mm.
were joint primary carers and would not be able to necessarily make an application for for themselves to be able to remain here in
Okay,
the UK.
okay,
So
okay,
I was just saying that in terms of those people who did not have the right to make a leave to remain application, the Zambrano route would have been the best option, or is still
okay,
the best
okay.
option for them.
All right. Quickly, let's go to the next caller. Yes. Hello, caller.
Hello.
Yes.
Good
What's your
afternoon.
name and where are you calling from, please?
Because of it, Doncaster.
Doncaster. Okay. You prefer to speak Chi?
Yeah, yeah.
Okay. Lawyer Eunice, over to you. Pachokasa.
Unif, Mema wa Hibim,
Yeah,
Apapa.
so.
Unif, me wo, how me no be, nam person busao. Me sister Bako ya application, the marriage application, ne Saka, ne Kata, ne card no, last week. But instead of 5 years, no, yeah, man, 2 years, expired 31st, 2024. The honor mean Tiafia Kaka. And I'm the second question. And me talk about also I application of an under EU close family. Since last July, and no my application, but I'm going to take biometric no if ye August more. It means say if 6 months next week, still a decision beyond by a also my amendment be on one. Me only got to check the question. I don't know. Now, my third question, dear, it means I met a number.
Mate, because at the end of the program, no, or the number better not just say what fret. Na appointments are now be lawyer Eunice Beboa. Why? In Timpacho, yeah, that's a say what fret. Lawyer Eunice better questions now will be seven. Why? Thank you so much. All right then.
Okay, so for the people who
Benefits
may
of
not understand
yeah,
what he
yeah,
was saying, he says that his sister made an application under the marriage route,
yeah.
and she received her BRP card, which is her biometric residence permit card, 2 weeks ago, and she was given leave up to 31st December 2024. And
Right.
then he wants to know why. And then the second question is to do with the fact that he has
Brother.
there are some should I say nephews or nieces that have made an application as close family members, and when it comes to the fact that they made the application sometime in August, but they still haven't received any decision as yet, and so he wants to know if there's any reason why that is. Okay, so taking the second question first, when it comes to our EU SS applications, it's to do with the fact that a lot of the cases that are being dealt with, I've had instances where they've sent emails to say, we acknowledge that you have made an application under the EU SS route. Your application is being processed. Unfortunately, we are unable to meet our standard processing time, but we will make a decision as soon as possible. And so you get those emails that would tell you that yes, they are trying to process it, and these are their processing times, but unfortunately they have not been able to meet their processing times, and so they will try and make a decision as soon as possible. And this is mainly due to they say the COVID restrictions. And so a lot of the time when they send that email, you just know that they are not going to make a decision in time,
Anytime
because
soon.
yes, because of the fact that maybe due to the backlog of cases, they are not making decisions as quickly as they would have if they were not restricted, in the sense that, well, most of them are working from home.
Yeah.
They don't have the flexibility of getting the documents unless it is uploaded. And then, of course, you have those that have um, easy accessibility to work from home, but some people may not. And so that in most cases has created that backlog, and they are having to deal with it, especially because they said over 3,000 people made the application before the deadline, which was December 2020. And then after that period of time, they are still having to deal with more and more people making applications under the EU settlement scheme. And so they are having to deal with more applications, and then having to also look at administrative reviews and the rest of it. So their workload has somewhat increased than they expected. So he should not be so worried. If after 6 months he still wants to know what's going on, he can send a complaint, because their standard period of service is usually a period of 12 weeks. So he can
Okay.
send a complaint on the Home Office complaints email, and then they will get back to him. And in regards to his first question, he was asking whether his friend's wife, who was granted leave to remain as a spouse, was given the right leave. So usually, any applicant who makes an application under our EU settlement scheme as a spouse will be granted 5 years, and of course, 5 years leave to remain. So it's not residence like it was under our EU regulations. So they'll be granted 5 years leave to remain. But in this instance, they haven't granted her 5 years leave to remain, and they have granted her instead up to December 2024. And that is to say that because, of course, the government is looking to go electronic with all of our leave and most of our information and everything else, they have given that specific date for the transition to making things, should I say, more accessible online. And so that date is just an indication of when that, should I say, transition is supposed to be. So he should not be so worried about the biometric card specifying
Okay.
December 2024. It is just because they will be making a transition at that time. And most biometric cards, even for indefinite leave to remain, will also have that as well, because of the fact that they are making that transition. And so, at the appropriate time, I'm sure the UK visas and immigration section will inform us as to how they will be going about this, so that we can inform
Okay.
applicants and clients as well. Yeah.
Okay. All right. So where we left off before the phone call started coming in,
Mhm.
Naneka is asking which approved test centers must one use in
Okay,
regards
so
to the English language
English.
requirement. Yeah.
Yes. Okay, so with the English language, there are those that will be making the application outside the UK, and those that will be making the application within the UK. So most of the time, if somebody were to be making an entry clearance application and they are to meet all of the requirements, including the English language, they will be taking it at an approved British council. So most British councils in let's say our Commonwealth countries and other countries will have the IELTS, which they would actually ask people to book online and then attend to take the test. And you also have those as well who would take the English speaking and listening, which is ISOL, in the UK. So with those people who will be taking those tests, they would usually have to take those tests at either the Trinity College London, and of course there is now the language set. I think it's a branch of the Trinity College London, and then you also have the Pearson Center. So Pearson Center also um, deals with English language tests in certain areas in the UK as well. So you have these three main, shall I say, test centers or approved centers where people can take the test within the UK. So, yes, if of course you Google them, you would be able to find their number and then take the test. Because if the test is not taken at an approved center, and I know that the changes came sometime in 2015, because prior to that, the test could be taken um, in most other places, but now it's streamlined and they want people to have them taken at those test centers where they can basically monitor and check and verify that they were the ones that took the test. Yeah.
Right, right. Okay. Ladies and gentlemen, this is getting more interesting. We've got so many questions coming through. I'll try my very best to go through all the questions, satisfy all of you. We are here for you. If you've just joined us, this is Hanging Out with BWF Solicitors. Your host, Vicky Newton. And with me is Mrs. Eunice Champon, a partner and lawyer at BWF Solicitors. Today, we've been discussing how important it is to meet the English language requirement when applying for leave to remain. Lawyer Eunice has taken us through what requirement is to be met, how to go through the process, and which test centers are the accredited centers for you to go and have the test done. If you want to contribute to the program, yes, we'd like to hear from you. You can do so on our Facebook and YouTube, all social media handles. We'll be able to pick those questions up and discuss it. If you prefer to contact us live in the studio, of course, you can do so on 0744 8619 711. The number again is 0744 8619 711. You can also WhatsApp me as well. Lawyer Eunice, which level must a person provide evidence that he or she meets the requirement?
So, depending on the leave that the person is applying, they will have to meet a specified common European framework level. So, usually, if for instance, a person was applying for leave to remain for the first time and they don't meet other requirements, they probably meet the English language requirement at a level A1, and they don't necessarily meet the immigration status requirement, they don't meet the financial requirement. Of course, if the only requirements are the relationship requirement and the English language requirement, and they have done a test meeting that level A1 standard, then they can use that as a way to say that, well, they meet the English language requirement, but they would still be put on the 10-year route to settlement because they have not met the other requirements.
Requirement, okay.
Yes. But if it were to be that they meet all the other requirements and they now have 2.5 years leave, they are going on to their second leave to remain, and they want to be able to show that they meet the English language requirement, then of course they can show that they meet the most basic form of the English language requirement, which is level A1. So, of course, if you are saying that you want to switch from the 10-year route to the 5-year route because you meet all of the requirements and you have a level A1 certificate to show that you meet the English speaking and listening requirement, then of course you can use that as a means to say that you have met the requirement. If for one reason or the other you haven't made an application for leave to remain and you're making the application now on your parent, as a parent or as a spouse, and of course you are looking to see if in the future you'll be able to use that to obviously make other applications. So for instance, you are making an entry clearance application as a spouse and you want to be able to meet that English language framework, and you know that the level A1 is the most common or basic level that you have to meet. You can do a higher one if you want. So instead of doing a level A1, which is the necessary or the most basic form of English that you have to meet, you can choose to do a level A2. A level A2 is also basic, or you can choose to go a bit higher. So a level B1 is a bit higher, or you could choose to go up a bit more, which is a level B2. So a level B2 is some form of independent speaking that you would not require the help or support of anybody else to be able to communicate with somebody else in English. So if for one reason or the other you have done an approved English speaking test at a higher level, and of course, you have made the application to come into the UK as a spouse. When you're making your subsequent application, you can rely on that test certificate to be able to make the subsequent application. And of course, if you are making an application for indefinite leave to remain, the standard level is meeting at least a level B1, which is also another form of meeting that independent level of speaking. So if it's a level B1 or a level B2, then you can use that when making your application for indefinite leave to remain. And of course, if you are making an application for British citizenship as well, they will need you to meet that level B1, should I say, common European framework standard. So there is always a certain level of English that has to be met. So A1 being the lowest, C2 being the highest. So it goes up the way it goes on alphabetically. So you have A1, A2, B1, B2, C1, and C2. So of course, the most basic level has to be met in terms of making a fresh application or making an application outside the UK. And then the highest levels can be met when making an application for indefinite leave or naturalization as well.
Okay. Okay. All right. Brilliant. May I also plead with those calling and the direct line? I would like to be very fair. Want to go online and take some questions from there, then come back to those calling us direct on our mobile phone. So please, 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 those calling us on our mobile phone, just give me few minutes to pick some few questions from those watching us on Facebook, YouTube, then get back to you to pick your calls as well. So thank you for your understanding. Yeah, Lawyer Eunice, I've got a question coming. This person doesn't want to be named. He doesn't want his name to be mentioned. Good afternoon. I'm applying for leave to remain as a parent on the 5-year route. I previously took the ESOL test about a year ago. When I was advised about what I will need when switching from the 10-year route to the 5-year route, my certificate states I have a level A1, and I use it when applying on the 5-year route. No, he says, can I use it when applying on the 5-year route? Right,
Okay, so if in his case he's taken the SO test already and he has met the Common European Framework level A1, then of course he can use that to make his application for leave to remain. As I mentioned before in the example that was given, if this is his first leave to remain application, it wouldn't matter so much because if, for instance, he doesn't meet the immigration status requirement, he will still be put on the 10-year route. But he says he's now switching to the 5-year route.
5-year
So
route, yeah.
if he's switching to the 5-year route, then of course, if he's making the application to switch, he
Mm,
could still use the level A1 certificate as a means to show that he has met the English language requirement. I'm glad he said that he took it last year because if he had said he took it 2 years ago, I would have said then it has a 2-year expiration date. So
expiration, yeah.
if
Mm,
you took it 2 years ago and you didn't use it for any application, that means that you will have to take the test again. But
that,
in his case, because it's just been a year, he can use it for the application. And then, of course, he should just bear in mind that when he's making any subsequent application,
mm.
he may have to do another one to meet the required framework level for the application he's making.
Okay, he's got a follow-up question as well. He
Okay.
wants to know if the same certificate can be used for subsequent applications for leave to remain. The same
Okay.
certificate.
So I would say yes and no because when you look when you look at the Home Office guidance, it says that it should be accepted if somebody has previously been as successful in using
Okay,
that English language certificate in making an application. It should be accepted by the caseworkers. But then you have our immigration rules, and our immigration rules, like I was saying before, is secondary legislation. So it supersedes the Home Office guidance or
right.
policy. And within our Home Office immigration rules, when you look at Appendix FM, it says that, of course, if the person previously made a successful application with the certificate and they were making a subsequent application for leave to remain, they will have to meet common European framework level A2. So no
Yeah.
longer would they accept the level A1. They will now have to meet the required Common European Framework level A2. So in his subsequent application, he has to go and do a different English language test to be able to meet that level A2. So this is obviously to do with them making changes to our immigration rules as and when they decide. And of course, when it comes to the English language test, he will have to meet that required level A2 in his subsequent application for leave to remain.
Okay. Right. Laura Eunice, I've got a caller on the line. Hello, caller. Your name and where are you calling from, please?
Hi, my name is Charles. I'm calling from Peckham.
Okay.
I would like to ask a question if the lawyer can help me out.
Yes.
I got my indefinite through my spouse.
Okay.
That was last year. I got the indefinite leave to remain exactly a year today.
Okay.
I want to find out if I want to apply for my British citizenship after staying on it for a year because we've already separated.
Okay.
So if I can on my own right, can I make the application exactly today, or it has to be a day after when I acquired my indefinite leave to remain?
Did you get the question?
So from what I understood from what he was saying, he's saying that he made an application for indefinite leave to remain in
No,
his.
I haven't made the application.
He hasn't.
Okay, so you're now going to make the application.
Indefinite leave to remain on the 12th of February last year.
So you do have your indefinite leave to remain.
He got his indefinite leave to remain on the 12th of February last year. So it's exactly a year today.
Okay.
Yeah, go on.
So if I want to apply for my citizenship or as in naturalization,
okay,
on my own right, can I make the application today or I have to wait a day after the 12th of February?
Lawyer Eunice, is it clearer now?
Yes, so I think I was trying to ascertain that he's got indefinite leave and he now wants to be able to make an application for naturalization.
Yes, and he's asking whether it has to be exactly 1 year or he can apply a day after the 1 year, which falls today.
Okay, so there, as soon as the 12 months is up, that's fine. They look at exactly 12 months. So it has to be 12 months from the date that there were no restrictions to his leave in the UK. So there isn't another day that could be added on to that. He can make the application immediately. I think he was saying that he got his stay because he was a spouse. And of course, if he was still married to his wife, he would have been able to make the application as soon as he got indefinite leave to remain. He wouldn't have to wait a day or 6 months or a year to be able to make the application. But because he is saying he's no longer together with his wife, he can make the application independent of his wife as long as he can show that he meets the other requirements. So he should be able to show that he's lived here continuously for a period of 5 years, which is a legal continuous residence of 5 years, and that of course he has had that indefinite leave to remain or no restrictions to his leave for the past 12 months, and that he's also not been absent from the UK for a period of 450 days in the past 5 years, and neither has he been absent for a period of 90 days in the last 12 months. And of course, he has to show that he is of full capacity, so he is mentally stable and the rest of it. And he will be able to show that he will make the UK his permanent home. So he should have every intention to make the UK his legal home. And he has to meet the English language requirement and the life in the UK requirement as well. So if he's able to meet all the other requirements, then he can make the application. Can you hear me? I think we can't hear you.
Yes, are you satisfied with your answer?
Okay.
Yeah, all right. Thank you so much for calling. Have a lovely day.
Thank you.
All right. Okay. Lawyer Eunice. Wow, another caller. Hello, caller. Your name and why you calling? I think you've called earlier, isn't it?
Yes, I called because I couldn't get the explanation.
Okay. All right.
I just
Go.
want to find out whether now we have to write C1 for our indefinite. I mean, the Zambrano at
Hold on, Lawyer Eunice, did you get the question?
No, I'm not sure. Is she saying that she wants to find out if they have to meet the English language?
Hold on. Can you hold on, my dear? Can you please turn down any TV or a device because we are getting feedback? We can't hear you.
Okay.
Yeah, I can hear myself.
Yeah, is it okay now?
Okay, now you can ask your question. Now it's clear. Lawyer Eunice is here.
So I just want to find out if we have to write C1 exam. That's all.
Okay, so you want to apply as a Zambrano carer, but you want to know if you have to meet the English language requirement.
I just wanted to know. Yeah. Thank you.
No, you don't need to meet the English language requirement. So under Appendix EU, the requirements are different to that of those under Appendix FM. So somebody who is applying as a Zambrano carer under Appendix EU will need to show that they have obviously lived here in the UK. If for a period of less than 5 years, then of
Yeah.
course they will need to provide evidence. Or if they've lived here for a period of 5 years or more, they will also need to provide evidence. If they are saying
Okay.
that they are a primary carer of a British citizen, they will need to provide evidence that they are a primary carer of a
Mm.
British citizen and that the British citizen depends on them. So there is no requirement to meet an English language test or to show that you'll be able to financially maintain the child, even though I've already said that you should show that the child is depending on you. So
Yeah.
in a way, you should be able to show that you are financially supporting that
Mm.
British
Mm.
child as well. So
Oh,
those requirements are different to those that are under Appendix EU of our
okay.
um, immigration rules.
Okay. All right. I will be very happy to receive one last call. So if you're planning to give me a call, please do so. I'll take one more caller. Yes. Okay, let me take another question from the platform. She says, does it matter if I don't have the certificate but have been given a provisional result of pass? Can I provide only the pass outcome? This is coming from Shirley.
Okay, so in terms of the English language test, I know that during the Corona period, when
Mm.
there were very heavy sanctions on people meeting in public spaces and the rest of it, there there was a lot of closure. So of course, a lot of centers were closed, or even when they opened up, they were given very limited, should I say, spaces or bookings for people to come in and do the test. And so I know that during that time, if you applied for some exception,
Mm-hmm.
they would consider that when making their decision. And so, of course, now that the rules are relaxed about meeting in public spaces and the rest of it, now, of course, most centers are opened for people to take their test and to be able to receive their certificates. I do know that, of course, once the test is taken, they don't give you the certificate straight away. They would let you know via email that you've passed, and then they will let you know that in about 3 to 5 working days, you will receive your certificate. And so, of course, once they've sent you an email that you've passed, that is a good thing. Doesn't The email doesn't necessarily come with whether you have met the common European framework level A1 or level A2 or level B1 or B2. It doesn't come with any of that. So that makes it a bit difficult, because otherwise, I would have said, do you know what? You can use that, because when you are making the application, it asks whether you have a certificate or an electronic number.
Right.
And the emails don't come with that electronic reference unless
Mm.
during the time of the corona, where they were not issuing certificates, they would give that reference number.
So,
And I know there were other times where reference numbers were being used because they were not issuing certificates necessarily. But obviously, if you are to receive a certificate within 3 to 5 working days, then I would say that do wait for the certificate, and then, of course, state that you have the certificate and you will be using that when making the application. So, yes, if you've been able to take the test and you've passed, you know that you will be issued with a certificate. So, you can bear that in mind when making the application, and go ahead and say that you do have a certificate, so that the certificate will come in time when you're going for your biometrics, because a lot of the documents will have to be uploaded by the time you are going for your biometrics. And so if she has passed at the required level framework level that is necessary, then she can go ahead and use that when making the application. It's also very important to know that when you're making the test, or should I say, when you're going for your test, if you are able to make the test at a higher level, then do so rather than at a lower level A1 requirement. I know most of the time it is good to start small and make your way up. But if you think that you can do it at a higher level, then do go ahead and complete the test at a level B1 or higher. So that, of course, that will be considered when you're making any subsequent applications.
Okay. Okay. Wow. Um, it's such an interesting, discussion we're having today. Um, all too soon, we've come to the end of this program. But if you have more questions for Lawyer Eunice, don't worry. Lawyer Eunice will leave her details at the end of this program for you to contact her, book an appointment, and she'll be able to direct you on what to do. Thank you so much. Before we end this program, I'll let Lawyer Eunice summarize everything and leave her details for the benefit of those who would like to contact her for further advice. Lawyer Eunice.
Thank you so much, Vicky. So, as Vicky has said, in rounding up, we were looking at satisfying the English language requirement and how important is it. So, yes, it is pretty important to meet the English language level framework for the specific leave to remain that you are applying for. So, like I've said, you may have a very basic level A1 English language certificate, but when you're applying for a subsequent leave, you should also know that although they can take that into consideration,
Yeah.
the rules change, and so they would also require that you produce to them a level A2 instead of a level A1. And you also need to show that you meet the required framework level when you are even applying for indefinite leave to remain or for naturalization. And so it's always good to know the kind of English language level, that certificate that they will need when making the right leave to remain application. Of course, if you need further assistance, not only with this issue that I have spoken about, but you have other immigration issues, or you do have family issues, or social issues, which include housing and the rest, do not hesitate to contact myself or contact our office, which is BWF Solicitors. We open from Monday to Friday, 9:30 a.m. to 6 p.m. Our office telephone number is 0208 493 7340. So it's 0208 493 7340. My personal number is 075 3581 3910. So of course we hope to see you all next week. Have a fantastic weekend.
Yes, 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 yes. We wish you all a fantastic weekend. I would like to also say a big thank you to all those who called us to ask their questions, those who send their questions on our social media handles. Thank you so much. If you joined the show, at the latter part, you've not missed a lot. I would advise you to go back on our YouTube, Facebook page at BWF Solicitors, and you get a recorded version. Sit down, relax, and watch from the beginning. And if you realize that you have, you need extra advice and support, Lawyer Eunice has, given you her details. You can contact her and she'll be very happy to help. On this note, I'll say thank you. Have a lovely weekend. We hope to see you same time next week. Stay blessed. Bye-bye.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernardo Wusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernardo Wusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.